All right, let's talk about objections that you would commonly hear at a trial, and I'm going to talk real slow so some of y'all can write it down. No, I'm just kidding. I'm going to make you watch it a couple different times. So there's hearsay, relevancy, more prejudicial than probative, improper character evidence, privilege, best evidence rule, not laying a proper foundation, not authenticating something, which goes along with not laying a proper foundation sometimes, calls for speculation, that one's used a lot, or lack of personal knowledge, improper lay opinion. Those are some of the most common objections that you will hear. Now, hearsay, remember, and we can't really get into all of the evidentiary rules on hearsay because there are so many exceptions and they're so nuanced. So what I would say is study that, learn it, live it, love it. So hearsay, the common response to the objection is not for the truth of the matter asserted. So if you ask something and it's a statement made out of court, then it is likely hearsay, but you can use it if it's not for the truth of the matter asserted. So if you are trying to say, this was said and it made little Johnny feel this way, then we can talk about it making little Johnny feel this way, even though what was said may not be true. So just know all the exceptions to hearsay and know that hearsay is a really big one. It's pretty important. When we're thinking about these objections, what I want you to really think about is, well, why is that the rule? Well, it's the rule because we don't want things coming in that just don't make sense to come in. Like relevancy. We don't want things coming in that are irrelevant. But be careful. One of the big things on, well, Your Honor, that's not relevant. Well, it is, Your Honor. It's relevant to show bias because bias can always be investigated through cross-examination to make sure that the witness is given the story because it's the story and not because they have some bias. So it may not seem relevant, but it can be shown to be relevant if it's there to expose bias. What about more prejudicial than probative? Well, that's that. Well, Your Honor, it's devastating to my case. If it is a really prejudicial thing, just because it's true doesn't mean it comes in. Because there are times where it is prejudicial, but it isn't necessarily important to this case. So many times, things can be more prejudicial than probative. What about improper character evidence? Well, that goes along with the more prejudicial than probative sometimes. Because if somebody has a particular crime that they've been convicted of, it might not be enough to be used as character evidence, but it certainly would make them look bad. So that is a improper character evidence and more prejudicial than probative. Let me see, what else? Okay, so the improper lay opinion. So an improper lay opinion would be when you are trying to get an opinion from someone that would typically require special education, knowledge, training, and they're offering up an opinion. You know, somebody says, well, you know, I estimated he was doing about 70 miles an hour. Well, if they've had no training on speed estimation, then that would be an improper lay opinion. So you need to make sure you object to those things. Now, calls for speculation, that is a question that would say, what do you think? Or what were they thinking? Or isn't it true that everybody out there was? So anything that would make somebody go, well, you know what I think? Well, that calls for speculation and it's not allowed. What about failure to authenticate? If somebody is trying to introduce some evidence and they just start trying to introduce it without proving what that thing is, then they have not authenticated it. They have not proved that that is in fact what it is said to be. So they have a letter and they say, well, here's a letter from John saying that he owes Bill $500. Well, if they have not gotten Bill or John to testify about that and say that that's what it is, then that would be improper because it had not been authenticated. And that would be the same for lack of foundation. Have not laid the foundation to say that that's what it is. What about the best evidence rule? Well, let's go back to that example with Bill and John, and it is a copy. Well, the best evidence would be the original, the ones with the blue ink signatures. So you would argue that the best evidence rule would say we need to have the original, not some carbon copy that we can barely read that could have been tampered with. What about privilege? Well, we all know that there are privileged communications with spouses, privileged communications with medical providers, and privileged communications with attorneys. And so sometimes we object because it is delving into privileged information. So those are some of the most common objections and when they would be used.